Okay, back on the religious freedom issue. One of our concerns, obviously, is judicial activism.
Yeah.
And I know this is something that you've talked about, you're concerned about as well. Judges who seem to be making law rather than interpreting law. How do you view this, and how can we, if you are president, what kind of judges would you appoint?
Right.
In particular, Supreme Court justices. We know elections matter, as we talked about earlier, and this is one of the big ways that elections matter. But do we have a problem with judicial activism in this country?
It is an enormous problem, and it is growing. If you look at in June, in the course of 24 hours, we had 2 decisions that were both utterly lawless. First, the Supreme Court, a handful of unelected judges, rewrote the text of Obamacare, ignored the federal statute to force that failed law on millions of Americans. 24 hours later, 5 unelected judges purported to tear down the marriage laws of all 50 states. Both of those decisions were lawless. They were judicial activism. There's not a word in the Constitution that supports them. And you know, Dr. Graham, this is an issue that really separates a number of the candidates running on the Republican side in 2016. Several of the Republican candidates, when the marriage decision came out, put out statements that effectively said, it's settled, it's the law of the land, we need to accept it, surrender, and move on. Those are word for word the talking points of President Obama. I can tell you, I, for one, do not accept it, am not willing to surrender, and am not willing to give up on the Constitution. And you know, Dr. Graham, you asked about judicial appointments. If you look at the court, almost every Democratic appointee on every big picture case, big issue case, votes 100% the way the liberals want them to. Republicans, we bat about 500, many of the most egregious judicial activists. Earl Warren, William Brennan, John Paul Stevens, David Souter, Harry Blackmun, who authored Roe versus Wade. Every one of those were Republican appointees. And the problem, we run into the same problem over and over again. You know, at the last debate, I talked about 2 moments in time. Number one, in 1990, when George Herbert Walker Bush had in one room David Souter, and in another room Edith Jones, the rock-ribbed conservative on the Fifth Circuit Federal Court of Appeals. And Bush 41 went with Souter. And then in 2005, George W. Bush had a similar choice, had John Roberts in one room, and had my former boss, Mike Ludig, the rock-ribbed conservative on the Fourth Circuit Court of Appeals, in the other room, and George W. Bush went with Roberts. Now, in both instances, it wasn't that the President Bushes wanted to put a liberal on the court. They didn't want that. But with Edith Jones and Mike Ludig, they had spent over a decade each on the court being a principled jurist following the Constitution. If you nominated them, you would have a fight. If you nominated them, Democrats would go nuts because they'd understand Mike Ludig was Antonin Scalia's first law clerks. They know exactly what they're going to get. And with David Souter and John Roberts, the advantage was they had said very little. They had no paper trail. And every single time we've gone with a judicial nominee who doesn't have a paper trail, it's turned into an utter disaster. So in the Republican field, every one of the candidates will sit down with you and tell you, I will appoint strict constructionists who will follow the Constitution and not legislate from the bench. Those are the talking points. Every candidate says it. The difference is who's willing to actually spend the capital and fight to do what they said. I have spent my entire adult life fighting judicial activism. There are few, if any, choices